Hey everyone, this is Sahil, Principal Attorney at Drishi Law, and today I'm going to talk to you about a specific kind of trademark protection, trade dress protection. Now, your brand building journey usually starts with a name, logo, maybe even a slogan, but trade dress protection is just another tool in your arsenal to expand your IP portfolio. And today I'm going to tell you a little bit about what that involves. Now, the first question you might ask is, what exactly is trade dress protection? What does it cover? Well, it's another kind of trademark protection that is offered to the total image or appearance of a product or service that is provided to the consumer. A trade dress typically includes a color scheme, a packaging, wrappers, labels, shapes, and all other materials utilized in the presentation of a product to the consumer. When the overall appearance of a product or service is distinctive enough to be a source identifier and meets the other requirements of a trademark protection, well, it meets the requirements to be protected as a trade dress. Although the distinctive qualities in that trade dress cannot be functional. And we'll talk a little bit more about that later. The three main categories of distinctive features that qualify for trade dress are: number one, product design or configuration. The shape or configuration of a product. Simple as I can put it, the shape of an Apple iPhone, the shape of a Weber grill. When you close your eyes and you think about what an Apple iPhone or Weber grill looks like, you can think of a silhouette. And though that distinctiveness needs to be acquired, it cannot be inherently distinctive. So Apple and Weber had to provide evidence to the USPTO to show that when consumers see that silhouette, see that design, see that shape, they think Apple, they think Weber. The second category, product packaging, labels, wrappers, boxes. Unlike product design, product packaging can be inherently distinctive. For example, the Coca-Cola bottle. And product packaging is extremely popular for protection in the alcohol and cannabis industry. Think of all the different types of wine, liquor, and beer bottles with their different labels and different designs. They all put in an immense amount of effort in protecting their intellectual property. The third category of distinctive features that qualify for a trade dress protection are other kinds of non-traditional trademarks, such as color schemes, motion marks, GIFs, sound marks, store layouts, scents and flavor, advertisements, websites, and so much more. Think of the inside of an In-N-Out or the inside of a Chipotle. If you were to walk into a store, but there were no signs saying it was Chipotle, could you recognize that it was a Chipotle? That's because companies like Chipotle, In-N-Out, and others have spent years, if not decades, in developing what kind of presentation. That's because these companies have spent decades developing a customer experience that is unique to their brand. And you can do the same. Next, you might ask is, how can you receive trade dress protection? Well, to receive trade dress protection, first, your trade dress must be distinctive. As I spoke about it earlier, your trade dress must have acquired distinctiveness or be inherently distinctive. And that rule applies differently on the different type of trade dress that you might be looking for. Now, the second requirement for trade dress protection is non-functionality. Non-functionality can be utilitarian or aesthetic. A trade dress feature is said to be functional if the feature is vital to the purpose of the product. A trade dress is said to have aesthetic functionality if it is essential, if it is a competitive necessity of the product offered. Aesthetic functionality usually comes up in luxury goods. For example, the red color of a Louis Vuitton shoe. Now, recently a court held that Yves Saint Laurent could make shoes with a red bottom as long as the red bottom was a full shoe and not just the sole. So in that scenario, Louis Vuitton's red bottoms are only protected to their red sole. What are the benefits of having a trade dress protection? Well, number one, presumption of ownership and validity. Number two, public notice. Number three, exclusive right to use that trade dress nationwide. Number four, the potential for indefinite term of protection. Number five, the ability to litigate federally if ever in the position to litigate. And number six, a basis for registering in foreign countries. You might ask, are there other intellectual property strategies that are closely related to trade dress protection? Yes, there are. Copyrights and design patents. Design patents protect the ornamental or decorative features of a manufactured article. They're limited to the non-functional aspect of the product, similar to a trade dress. Now, usually people pick the design patent process because it's faster than the trade dress process. A copyright application will protect the design of the product. As mentioned in my copyright video, The copyright application must be filed within 3 months of the first public notice of the product design. Think of the first thing that comes to your mind when you think of a candy wrapper, a store layout, or a color scheme. If you can think of something that is distinctive enough and it's the first brand that you think of when you think of these 3 different categories, I want you to list those in the comments below, because I want you to think about how these companies have spent decades in trying to get you to identify them when you think of these 3 things. As always, thanks for watching, and if I can help you with trade dress protection or any other kind of intellectual property matters, please feel free to book a discovery call in the link provided below.